Welcome. Today we're talking about judicial review. Judicial review is the power of the courts to declare that a law or government action violates the Constitution. This power is central to our system today, but it is not written explicitly into the Constitution. The Constitution never says courts may strike down laws. So where does that power come from? To answer that, we start with a case, and with a problem that sounds technical but mattered enormously. In the early republic, a judicial commission was a physical document. It was proof that someone held an office. Without that document, you did not have the job. William Marbury had been appointed as a justice of the peace. The president signed his commission, the seal was affixed, but the document was never delivered. A new administration took office. The new Secretary of State refused to hand it over. Marbury went to the Supreme Court and asked for a specific order, an order commanding the executive branch to deliver his commission. That kind of order is extraordinary. It tells another branch of government to perform a specific act. Chief Justice John Marshall recognized the danger immediately. If the court issued the order and the executive ignored it, the court would look powerless. If the court refused to act, it would appear to submit to executive control. Marshall chose a third path. He explained that Marbury was legally entitled to the commission, but the executive branch was wrong. But the court still denied relief. Why? Because the statute Congress had passed gave the Supreme Court authority that the Article 3 did not allow, and Congress cannot expand the court's original jurisdiction. When a statute conflicts with the Constitution must control. That reasoning established judicial review, not as a power grab, but as a necessity. Judicial review did not stop with Marbury. It operates every day, and it applies across the entire constitutional system. Judicial review is how courts check Congress. For example, in the United States v. Lopez, Congress passed a federal law regulating gun possession near schools. The Supreme Court held that Congress had exceeded its powers under the Commerce Clause. The law was struck down not because it was unpopular, but because the Constitution did not authorize it. That is judicial review, placing limits on legislative power. Judicial review also limits the executive branch. In Youngstown Sheet and Tube v. Sawyer, President Truman ordered the seizure of private steel mills during the Korean War. The Supreme Court ruled that the president lacked constitutional authority to take that action. Even during a national emergency, executive power has limits. That is judicial review applied to the presidency. Judicial review also reaches the states. In Obergefell v. Hodges, state laws defining marriage were challenged as unconstitutional. The Supreme Court held that those laws violated the 14th Amendment. As a result, state laws across the country were rendered unenforceable. That is judicial review, ensuring the Constitution means the same thing in every state. Judicial review is therefore powerful but limited. Courts cannot act without standing, without ripeness, without a live controversy. They do not issue advice. They do not resolve political disputes. They decide cases. Judicial review does not place judges above the Constitution. It places the Constitution above every branch of government. That is the balance. That is the limit. That is judicial review.